There's been a dispute between Thom Browne and Adidas in the US, but what's happened? Hello, I'm Dominic Walker. Welcome to JMW's Inside Man YouTube channel. Please subscribe to the channel, like this video, and keep the conversation going in the comments section as well. So Lucy Marlow is a senior associate solicitor within JMW's intellectual property department. So Lucy, I've mentioned this dispute between Thom Browne and Adidas. Why are these two businesses at loggerheads? What's happened here?
So Adidas filed a lawsuit in the New York courts claiming that Thom Browne had infringed their trademarks. In essence, it's a trademark dispute concerning Adidas's iconic 3 stripes versus Thom Browne's 4 and 2 stripes that they're applying on sports clothing. And at the heart of Adidas's claim is that ultimately consumers are going to be confused given Thom Browne's presence in the sports apparel industry as to where these products are originating from.
And you mentioned that key word in any intellectual property dispute, confused. I mean, only just a few weeks ago, I was in a sports shop with my 6-year-old and I was explaining to him about Adidas and the 3 stripes. So surely it would cause confusion if anybody else, had stripes on products, including Thom Browne.
Well, that's one of the arguments raised by Thom Browne's counsel, which is that Adidas can't have a monopoly over all stripes, and that actually it's part of a common design and it's very commonplace. But really the reason here why it was that Thom Browne actually ultimately won is that the judge accepted the argument that there wasn't likelihood of confusion in the circumstances where both of the companies had very different positions in the marketplace and they compete at very different price points. So Thom Browne is a very high-end luxury retailer. For example, a pair of leggings cost £680. A polo shirt costs £270, like far more expensive than Adidas. And that's ultimately, what meant that Thom Browne won the case.
And it feels to me, and correct me if I'm wrong, very sort of David and Goliath, doesn't it?
Yeah, definitely. And that's actually something that Thom Browne came on the record saying, which is that, they've been quite open, saying that they hoped that this case would inspire others to challenge larger companies, which presumably in Thom Browne's case, they felt over-asserted their rights.
And more generally, how can you and the team here at JMW Solicitors help anybody who, may even be involved in a David and Goliath situation?
Sure. So it's really a case of assessing the case at the very outset. So if on one hand, you're thinking of launching a claim of infringement, it's important to assess the strength of the rights that you're relying upon. I'm sure we can all remember when McDonald's launched litigation against a smaller takeaway outfit in Ireland involving the Big Mac, and ultimately that resulted in McDonald's losing its Big Mac trademark. So you need that initial input to determine where you stand. And if for example, you're defending a claim, again, it's very important that you have IP specialists involved that can assess the claim's been advanced and advise you as to your strategy.
Lucy, thank you so much for your insight. And if you'd like to contact Lucy and the intellectual property team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.